Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 98. First case this week, it looks at the definition of direct discrimination and what characteristics are protected. Since it's a Supreme Court decision, it's an important case for employment law, although hopefully the fact pattern itself is not going to be relevant to many employers. Secondly, we have a case on the ambit of the ACAS code on disciplinary procedures and circumstances, in which and the failure to comply with the ACAS code and whether it results in an uplift of damages on the particular facts of that case. And thirdly, there's a really interesting case dealing with a discretionary bonus and a shortcut which the claimant is seeking to try to achieve the recovery of the bonus. As usual, please don't forget, you can access the podcast via iTunes, the Mayor Brown Internet, YouTube, and the Twitter feed, Nicholas Robertson at Nicholas, ROBER11. And that's where, of course, we always put out the links to the cases. So, first case, Taiwo and Olegbe and others, and Onu v. Akwiwu and others. So it's two joined cases. And it's a Supreme Court decision, as I said at the start, dealing with the extent of direct discrimination and the ambit of protection. The case concerned migrant workers who came to the UK on a domestic work visa. As such, they were covered by English employment law, were entitled to various statutory protections. They included national minimum wage, rest breaks, etc. Both the cases, which were joined for the purposes of the Supreme Court hearing, saw individual migrant workers being treated terribly by their employers. In addition to verbal abuse, there was failure to provide appropriate working hours, there were terrible living conditions, and they were denied statutory protections. They were eventually able to escape these conditions after a period of time, and each eventually brought employment tribunal claims. The employment tribunal, hearing the claim brought by Ms. Onu, decided that she had been treated as badly as she'd been because her employer was able to exploit the fact she was a vulnerable migrant worker. Her entry to the UK involved a series of annual visas, and if she left employment, she'd be obliged to leave the UK immediately. As such, her job and her position in the UK were precarious. On that basis, the Employment Tribunal felt that her immigration status was clearly connected to her race, and therefore she was treated adversely on the grounds of her race, i.e. direct race discrimination. Although she had also brought an indirect discrimination claim as well, the Tribunal did not go on to consider it, because she'd won her direct discrimination claim. The AT disagreed and found that the direct discrimination claim had not been made out. The Taiwo claim was also for direct and indirect discrimination. However, here the Employment Tribunal confirmed that she had been treated badly, but found that although she'd been treated badly because of her vulnerable status as a migrant worker, this did not amount to direct race discrimination. And similarly, there was no indirect discrimination, as there was no provision, criterion or practice that she could put forward to show that this had been applied to her that was indirectly discriminatory. And the EAT agreed with this tribunal decision, both on direct and indirect discrimination. So, by the time the Court of Appeal were involved, both the individual claimants were appealing against decisions that there had been no direct and no indirect discrimination. The Court of Appeal heard both the cases together because they were obviously important issues, shared common ground, but rejected the appeals. So matters went on up to the Supreme Court, and the Supreme Court rejected their appeals. In relation to the direct discrimination claim, the Supreme Court was willing to accept that an individual's immigration status is connected with their nationality. Direct discrimination under the Equality Act includes protection against discrimination on the grounds of nationality. So the question for the Supreme Court was, is discrimination on the grounds of immigration status sufficiently close to discrimination on the grounds of nationality to be protected by the Equality Act? The Supreme Court decided it was not sufficiently close. First, many individuals who come to the UK to live here are not similarly vulnerable. In other words, it was their status and the particular terms of entry which made these workers vulnerable rather than their nationality. The employers would not have acted as badly had the individuals not been vulnerable on the grounds of their immigration status. Putting it in my terms, the immigration status was a step too far, a link too far from nationality to be covered by the legislation prohibiting direct discrimination on the grounds of race. Similarly, as the Supreme Court Court pointed out, had Parliament wanted to cover immigration status as being a matter of a protected status, then it could easily have done so and made an amendment to the Equality Act. Supreme Court also confirmed that there was no indirect discrimination claim available. There was no provision, criterion or practice applied to the individuals, and indeed counsel for the claimants conceded as much. Clearly, the Supreme Court felt that these individuals had been treated disgracefully from the facts found by the Employment Tribunal. Part of the problem was that the remedies for that disgraceful treatment were piecemeal and limited. Financial compensation was available for breach of some of the statutory rights, e.g. national minimum wage and so on, but with all the complexity and cost and stress of bringing a tribunal claim. Moreover, those remedies took no account of the pain and suffering the individuals had gone through, and the Supreme Court commented that it would be open to Parliament to introduce a remedy for breach of the Modern Slavery Act, the 2015 Act, and this could be something that Parliament might consider, giving a right in an employment tribunal for a claim for breach of that legislation. From my point of view, that certainly looks like an idea worth considering. Clearly, one hopes that in an ordinary commercial environment, behaviour of this type would be extremely rare. But I think it's important to see the Supreme Court's reasoning. The Court looked at what the Tribunal found to be the motivation of the employer, and they were not prepared to stretch the protections offered by discrimination law to cover migrant status by itself as amounting to discrimination on the grounds of nationality. Had the case gone the other way, it would have been open in an ordinary commercial environment for individuals to claim they were being treated adversely on the grounds they were here as on a work permit basis, rather than having a right to reside here, for example. So, to that extent, the case, if it had gone the other way, could well have had knock-on consequences for employers in rather less extreme circumstances. So, that's the case of Taiwo, Olegbe, Onu and Akwiwu. Next up, Holmes and Kinetic. Kinetic being spelled Q-I-N-E-T-I-Q Limited. And this is a case to do with the ability of a tribunal to award an uplift on damages. Under the ACAS Code of Practice on Disciplinary and Grievance Procedures, various standard and sensible steps are set out for an employer to follow in order for a dismissal to be fair. The Trade Union and Labour Relations Consolidation Act 1992, as amended, now states that if the code applies to the matter in hand, and there's been a failure to comply with the code, and that failure is unreasonable, then the Employment Tribunal may, if it considers it just and equitable, increase the damages award by no more than 25%. Just to complicate things, the non-statutory guidance which sits alongside the ACAS disciplinary code itself covers matters dealing with ill health terminations. ACAS has stated elsewhere that it believes that ill health matters should not be viewed as disciplinary issues where unless there is reason to doubt the genuineness of the reason for the employee's absence. So, the ACAS Code of Practice expressly excludes terminations by reason of redundancy or for the non-renewal of a fixed-term contract when it expires at the end of its natural term. It expressly includes dismissals for conduct and performance. You can see where this is going, can't you? Does it apply to ill health dismissals? Well, the facts of the case are exactly what you'd expect. The individual worked as a security guard for nearly 20 years. He has a variety of absences, some for lengthy periods of time. He is in the end dismissed by reason of ill health on the basis that he's not capable of doing his job. It's not suggested his absence was anything other than genuine. The dismissal was unfair because the employer had not gone through the necessary step of obtaining an up-to-date occupational health report before terminating. The Employment Tribunal, when awarding compensation, declined to grant an uplift on the damages. They said that the ACAS Code of Practice on Disciplinary and Grievance Procedures did not extend to covering terminations on the grounds of ill health, where there was no suggestion that the individual was to blame for his absences. The EAT was asked to overturn the Employment Tribunal's decision. It considered several points on the original decision, but I'm going to focus on the ACAS Code point. The EAT described the Tribunal's reasoning as, quote, clear and compelling, unquote. The EAT accepted there was no specific definition of disciplinary sanctions, and they accepted it could include misconduct and poor performance, but it was not necessarily limited, disciplinary situations not necessarily limited to only misconduct and poor performance. But attempts to persuade the EAT that a disciplinary sanction concluded termination by reason of ill health on these facts failed. The EAT were clear. The code applied to cases where an employee's alleged actions or omissions involved culpable conduct or performance that required correction or punishment. Disciplinary action ought not to be invoked by the employer if there is no conduct or performance requiring correction or punishment. As a concept, quote, poor performance, unquote, which is covered by the ACAS code, could be both culpable poor performance and non-culpable. If it was for genuine illness or injury, it was difficult, according to the AT, to see how disciplinary action could be invoked or justified. On that basis, the code did not apply. And, the AT pointed out, this was consistent with the earlier EAT decision of Lund and St Edmund's School, Canterbury, which also focused on the need for culpability on the employee's part. The case, it's a useful one for employers. Clearly, in an ideal world, an employer would have followed a fair procedure, irrespective of whether or not the ACAS code applied. However, to the extent that the ACAS code allows a tribunal to impose an additional sanction of up to 25% of the damages, it's helpful to have guidance indicating the limits of the application of the ACAS code on disciplinary and grievance procedures. So that's the case of Holmes and Kinetic Limited. Third and final case, Simpkin and Barclay Group Holdings plc. This is a really interesting case on a claim where an individual asserted he should be treated as a good leaver rather than a bad leaver. Now, full disclosure, at this time we haven't seen a full copy of the judgment. I'm going from a summary of the case which is circulating. The full judgment is not going to be available, the full decision apparently isn't going to be available until early August. But I think it's a really interesting case from the summary, so I thought I would take a look and offer some thoughts. Facts, apparently, the defendant company employed Mr. Simpkin as its group finance director. He was a member of a bonus scheme and was eligible under two separate long-term incentive schemes. In what looks to be the normal way of these things, if the individual ceased to be employed, then eligibility under the bonus and the LTIPs ceased. However, there was a general discretion which allowed an individual to be treated as a good leaver by the board, notwithstanding the fact that he had left. The individual in question, Mr. Simpkin, is dismissed, and after considering matters, the board of directors of the company decided he was not going to be viewed as a good leaver. Therefore, he forfeited benefits under the scheme. At this point, while war seems to have broken out, there are apparently whistleblowing allegations made, tribunal proceedings are started, tribunal proceedings are adjourned because of the High Court proceedings which were commenced, seeking effectively recovery of these benefits, and I think something like £10 million worth of benefits, so clearly it's something worth arguing about. At this point, so far, the issue is whether or not there should be a trial of a preliminary issue as a shortcut to establishing whether or not the claimant should have been treated as a good leaver. The interesting twist was the claimant argued it wasn't necessary to have a full trial of the facts underlying his conduct and behaviour. Instead, the claimant asserted it was sufficient to look at the minutes of the board meeting which had decided he would not be treated as a good leaver. The claimant argued that simply by looking at those minutes themselves, it would be possible to determine that he should have been treated as a good leaver rather than a bad leaver. I should add 2 points in passing, of course. First, before we go any further, the case is continuing, so no facts have been determined one way or the other. And secondly, according to the summary, company's lawyers were in attendance at the board meeting and prepared the relevant minutes of the board meeting. In essence, the High Court agreed with the claimant. They were willing to order a preliminary hearing on the issue of whether or not the decision to treat him as a good leaver, based on what was recorded in the minutes themselves, would determine whether it was lawful or unlawful to treat him as a bad leaver, or not to treat him as a good leaver. In other words, and going from the summary, it looks as if the judge was willing to say the employer was held to the points set out in the minutes of the board meeting, which resulted in the individual being found not to be a good leaver. Now, bear in mind the case continues, so the underlying allegations have not been decided, and we've not seen a copy of the board minutes themselves. Equally, we don't know to what extent the board minutes summarise points which were set out in full, apparently, in the defence to the tribunal proceedings and the High Court proceedings. So it looks as if the board minutes make some point the tribunal defence and the High Court defence filed by the employer much fuller. But this case seems to be a clear warning. It's maybe a shock for employers about the need to ensure that board minutes, or committee minutes, if it's a remuneration committee issue, for example, if that's where discretion is vested, set out fully the basis for determining whether someone is or is not a good leaver. We did have a discussion in the group meeting here as to whether an employer might do better to say, record a decision, have no reasoning. It's probably better to do that than to have poor reasoning, which might very well cause difficulties. But clearly, the optimum is to set out full and proper reasoning so that the justification for determining that someone is or isn't a good leaver is very clear. Here, the claimant obviously believes the board minutes reasoning is weaker from the employer's point of view than the overall picture. To that extent, the claimant seems to have succeeded in turning this into an issue of what is in the board minutes and whether that sufficiently defends his claim. Whether this works or not, we will find out in due course. But I think it's a really important lesson for employers. If you take a shortcut when drafting board minutes, and the reason you give for taking a particular decision about an individual status as a good or bad leaver, this can easily come back to haunt you. Whether it does in this case, only time will tell. There may have been no such shortcut taken. But it is interesting that the claimant is pushing to have this case determined solely on that basis. Obviously, in some ways, this case raises as many questions as it answers. For example, if the employer had ample grounds on which to decide an individual was not a good leaver, but the procedure adopted to get to that reasoning was poor, or it included irrelevant considerations, a court might find the determination that the individual was not a good leaver could not stand. However, does that mean the individual has necessarily to be found to be a good leaver? Is it a one-shot only event? Alternatively, if the company's practice is an individual who leaves for any reason is a bad leaver unless there are exceptional circumstances, does that mean the employer has to work less hard to show the individual as a bad leaver? Or that a failure to consider matters adequately still leave you with a default position, i.e. bad leaver? Anyway, I think when we see the full decision, some of this will become clearer, and it's, I would have thought, pretty apparent that other employees will follow in the path beaten by this case. Equally, employers are going to be well advised to make sure that the board minutes are sufficiently detailed and accurate to set out clearly the basis for the finding that an individual is not going to be treated as a good leaver. So that's the case of Simpkin and Barclay Group Holdings plc. So thank you very much indeed for listening. While I think of it, please do listen to the Paul Goulding podcast that we did last week. Really interesting podcast on restrictive covenants, recent developments in relation to restrictive covenants, based off the back of the latest edition of Paul's book, his excellent book, Employee Competition. And in fact, there is a competition on the podcast to win a copy, a signed copy nonetheless, of Paul's book. But listen to the podcast and you'll find out the details of the competition. So this weekend I'm off to the first of my festivals. I'm off to Latitude Festival. Keep thinking I should be wearing a podcast T-shirt. Have you seen the view? But that might be a little bit sad. But anyway, off to Latitude. So you know the pack drill. Weeks to come, I'll be banging on about great bands that I've seen and so on during my summer festivals. And I think the only other thing that it remains for me to confirm is that I think I can truthfully say that no apologies were used in the making of this podcast, unless, of course, you know better. Thank you.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.